Hi friends, let's discuss about Corporate Laws Amendment Bill 2026. I am explaining about 9 key changes and this is taken from the editorial of Business Standard titled Enabling Environment. Corporate Laws Amendment Bill 2026 was recently introduced in Lok Sabha and has been referred to the Joint Parliamentary Committee for examination. With the aim for a better ease of doing business and keeping laws relevant to the fast-changing business environment, the bill targets amendments to the Companies Act 2013 and Limited Liability Partnership Act 2008. Some of the proposed amendments are as follows. First one, special NCLT benches to speed up cases. The bill will allow the President of India to create special benches of National Company Law Tribunal (NCLT) to speed up the cases filed under Companies Act 2013 or the Insolvency and Bankruptcy Code 2016. What is NCLT? The National Company Law Tribunal is a quasi-judicial body in India established under Companies Act 2013 and operational since 2016. Quasi-judicial body means it is not a court exactly, but one which has most of the powers as that of a court. NCLT handles cases related to Companies Act 2013 as well as the cases under Insolvency and Bankruptcy Code 2016. The cases under Companies Act include mismanagement, merger issues, director disqualification, etc. What is the current problem with NCLT? NCLT has only 16 branches in India. As per law, NCLT has to find a resolution plan by 330 days from the day a case is filed, or else the company will be liquidated to settle the dues of its creditors. NCLT has been witnessing a rise in cases, especially after COVID, more than what its 16 branches can handle. This led to the average resolution time jumping from its 330-day target to more than 700 days. When such delays happen, the company's assets value will erode, which means less money will be recovered during its liquidation process. Majority of the cases filed with NCLT belongs to the non-IBC category. That is related, most of the cases are related to Companies Act 2013 and this is a major cause for lag in the IBC cases or resolvency cases. So what does the amendment try to achieve? Through this amendment, the government is planning to increase the number of benches of NCLT from the current 16. This will help in reducing the workload of existing benches. In addition to this, Parliament is also discussing the Insolvency and Bankruptcy Code Amendment Bill 2025, which aims to quicken insolvency resolution process. The bill was introduced in August 2025 and aims for faster insolvency process. Together, these both bills will improve the insolvency resolution framework in the country. The second point is centralizing merger applications at a single NCLT bench. What is a merger? Merger is a legal combination of two or more companies into one entity. Why is National Company Law Tribunal involved with the merger of two companies? The merger of any two companies, no matter if they are healthy or distressed, once the merger agreement is approved by the company's board, it needs of the tribunal to ensure fairness, creditor protection, and compliance. What is the current problem with this merger approval by the tribunal? The tribunal has to approve a merger in 90 to 120 days, but in reality, it takes way more time than that. With this amendment, the government is planning to centralize all the merger applications at a single dedicated NCLT branch. This should speed up the merger process. The third point is raising the CSR applicability threshold. CSR, also known as corporate social responsibility, mandates companies to spend 2% of net profits on environmental and social well-being. It aims to improve society and minimize any negative impacts caused by the corporation's activities, example pollution caused by coal companies and so on. CSR is applicable only if the company has any one of the following. Either their net worth should be more than or equal to 500 crores or their company turnover should be more than or equal to 1000 crore or their net profit should be greater than or equal to 5 crore. Now, through this amendment, this net profit section, the government is planning to increase the net profit threshold from 5 crore to 10 crore. This will give relief and ease the burden on relatively small companies. Fourth point is easing regulatory burden on small firms plus increase personal liabilities for KMPs. KMPs means key managerial personnel like CEO, CFO, MD, and so on. Through the bill, the government aims to reduce the burden on smaller companies by expanding the definition of what is small, as well as providing exemption of auditing, board meetings, CSR compliances, and so on. The government wants to reduce the regulatory burden on smaller companies, as well as the government is planning to tighten the accountability of key managerial person by bringing about changes that would ensure strict action for KMPs if things go wrong. The next point is curbing the non-audit services offered to a company. We have seen in one of our previous videos where we have explained how compromises to audit quality may happen if the firm providing audit services also provides lucrative non-audit services like consulting, tax advisory, or valuation to the client. This would affect the audit quality. An auditor is usually appointed for a specific period of time. After that time, they or some other auditor have to be again appointed. Under our current Indian law, while an auditor is in their tenure, they cannot offer non-audit services. But soon after their tenure is over, they may provide non-audit services. Through this amendment, the government plans that once an audit firm's tenure with its client is over, for the next 3 years, it cannot offer any non-audit services to the company or its affiliates. Through this, the government plans to maintain the audit quality and avoids conflict of interest. The sixth point is companies can do 2 buybacks per year. What is a buyback? Buyback is when a company repurchases its own shares from shareholders using surplus cash. It reduces outstanding equity, which leads to increase in earnings per share. Why do companies do buyback? For different reasons, but primarily when the management feels that the company stock is undervalued, that is, if the share is trading below its intrinsic value, then a buyback would result in price rallies. What does the current law say? Companies can do only 1 buyback per year. 1 year after that buyback, the company cannot, within that 1 year, the company cannot make fresh issues or do another buyback. This takes away the flexibility of a company in deciding the timing of the buyback. Through the amendment, the government plans to allow 2 buybacks per year for certain classes of companies and subject to other conditions. This lets firms respond faster to share price dips or cash surpluses without waiting for a full year. The seventh point is granting NFRA with rule-making authority. Now, this is a very good change. National Financial Reporting Authority, NFRA, is India's independent statutory body overseeing audit quality for listed large firms and recommending accounting or auditing standards. Currently, NFRA only has recommendation power. It recommends the standards and policies. It lacks direct rulemaking powers like SEBI for securities or IRDAI for insurance. NFRA can enforce compliance, but it cannot independently issue binding regulation. Through this amendment, the government plans to grant NFRA with rulemaking authority equivalent to other financial regulators, enabling it to directly prescribe, amend, and enforce accounting standards, audit norms, and oversight rules without government intermediation. This would align India with global norms, reduce audit frauds or manipulation, and generates a trust in the system. The eighth point is conversion of AIF structures from trust to LLPs. What is an AIF? Alternate investment funds are pooled investment vehicles regulated by SEBI for high net worth investors. Pooled investment vehicles are investment structures where multiple investors, that is high net worth investors, combine their money into a single fund, enabling collective investment in assets like stocks, real estate, or private equity that individual investors could not access alone. AIF is currently structured as trust under Indian Trust Act 1882. Trust has many problems such as taxation issues, no codified rules for protecting the investor, rather it depends only on contracts, and so on. Through this amendment, the government plans to convert AIF trust to limited liability partnership under the LLP Act 2008. Benefits of AIF converting to LLP is taxation clarity, protection available for partners, that is investors, aligns with global practice, and it would attract foreign investments. The last point is companies can conduct AGM, EGM through video conferencing. AGM, annual general meetings, and EGM, extraordinary general meetings, are both mandatory shareholder meetings where AGM happens yearly for financials approval or dividends. EGMs are conducted as and when necessary for urgent issues like fundraising. Currently, AGM or EGM has to be conducted in physical mode. But when the COVID came, MCA, Ministry of Corporate Affairs, allowed companies to conduct AGM or EGM over video conferencing or other audiovisual modes. But that was a temporary relief. Through this amendment, the government plans to permanently enable video conferencing or other audiovisual modes for both AGM and EGM, subject to condition. This progressive move would help in cost savings for the company, and since more shareholders can participate from different corners of the world, it increases participation of the meeting as well, which will lead to good results. In summary, the Corporate Laws Amendment Bill 2026 has several provisions that would improve the business environment of our country to a great extent. Thank you.